Question 1. Azin, who careered as an accountant for more than 3 decades, had been employed as a director of Smart Invest Berhad, a public investment company. In discharging one of her main duties, she is required to prepare the financial statements according to the basic standard guidelines and framework. Azin, however, had negligently prepared such documents when it involved a series of major misstatements and miscalculations. This would never be expected from Azin, who has deemed to have a vast experience in the said practice. Following a huge loss and setback, the company had dismissed Azin and sued her for damages. Advised Azin accordingly.
Whether the company had dismissed Azrin and sued her for damages.
Next, I would like to talk about the relevant provisions that related to this case based on Sections 165 of Contract Act 1950. An agent is bound to conduct the business of the agency with as much skill as is general possessed by person engaged in similar business, unless the principal has notice of his want of skill. The agent is always bound to act with reasonable diligence and to use such skill as he possesses, and to make compensations to his principal in respect of the direct consequence of his own neglect, want of skill or misconduct, but not in respect of loss or damage which are indirectly or remotely caused by such neglect, want of skill or misconduct.
Hello, my name is Lovina Anna Anthony. My number entry is 20D8024F1055. Today I would like to present about relevant case. Question 1. About case Keppel versus Wheeler, 1927. The fact is the defendant was employed by the plaintiff to sell his house. An offer was received and accepted by the plaintiff subject to contract. A few days later, a higher offer for the same property was made by X, but this offer was not communicated to the plaintiff. A written contract of sale between the plaintiff and the first offer was duly signed. Decision by court is the defendant was liable to the plaintiff for the difference between the two offers. The inference is that the agent must disclose everything coming to his knowledge, which is likely to influence the principal in the making of the contract.
My name is Felicia Era Anak Kennedy. My numeric is 20D8024F1039. I will explain about conclusion. As a conclusion, Azrin should be responsible to pay for the loss of Smart Invest Berhad and pay for the damages of her negligence. This is based on case of Keppel v. Wheeler 1927 by Section 165 of Contract Act 1950. It can be concluded that Azri should be liable to pay the loss of company and for her damages.
Question 2. Reza wants to sell his Range Rover to any interested party in order to raise his personal fund. Through an advertisement, he had coincidentally met his old friend Lina 15 March 2025, who agreed to buy at the price of 550,000. Convinced that Lina will settle the payment in full on 1st April 2025, Reza had immediately transferred the car to her on the same day. Unfortunately, there was no any payment effect on 1st May 2025, and Reza therefore realized that he had been cheated. When Reza wanted to claim and repossess his car back from Lina on the next day, he found that it had been sold to Salim, a third party who had bought it in a good faith. Advised Reza accordingly.
Issue of case: whether Reza can sue Salim and claim his car, and did Lina need to pay full settlement to Reza.
relevant provision for question 2. Section 30, subsection 2 of Contract Act, seller or buyer in possession after sale, where a person having bought or agreed to buy goods obtained with the consent of the seller possession of the good or the document of title of the goods, the delivery or transfer by that person or by mercantile agent acting for him of the goods or document of title under any sale, pledge or other disposition thereof to any person receiving the same in good faith and without notice of any lien or other right of the original seller in respect of the good shall have effect as if such lien or right did not exist.
I want to going to present a relevant case for question 2. Newton's Wembley Ltd versus Williams. Plaintiff, the true owner, sold the car to the first buyer. Payment was made by check. It was agreed between the parties that the title would only pass when the check was honored, but the plaintiff had given possession of the car to the first buyer. The first buyer subsequently sold the car to the second buyer, who in turn sold it to the defendant. The check was dishonored and plaintiff attempted to recover the car from the defendant. Decision of court is the first buyer who was in possession of the car with consent of the true owner could pass a good title to the second buyer, who in turn transfer it to defendant. Plaintiff action failed. He could only claim the price from the first buyer.
And for the conclusions, therefore, based on Section 30, Subsection 2 of the Sale of Goods Act 1957, the transfer of ownership to Salim is valid. Since Salim purchased the car in good faith and without knowledge that Lina had no right to sell it, he is protected under the law and can retain ownership of the car. And Rina needs to settle her payment to Riza. Riza likely cannot repose the car from Salim.